purchase is a process whereby the seller is considered the vendor, the buyer is considered the hirer, and the lending company is considered the owner. The Hire Purchase Act 1967 is a Malaysia's hire purchase statute. However, this law does not extend to all goods on hire purchase. This act applies only to hire purchase arrangements involving goods specified in first schedule of the act. Common law regulates contracts to employ other products. Hire purchase agreement can be specified under Section 2, Subsection 1 of the Hire Purchase Act 1967, which requires a lease with a purchase option and a payment plan to purchase goods. Goods specified in HPA's first schedule are all consumer products, motor vehicles, including invalid carriages, motorcycles, automobiles, including taxi, cabs and hire cars, and goods vehicles with a maximum load not exceeding 2,540 kilograms, and buses, including stage buses. The scope that covers in both cases is the Hire Purchase Act 1967. It imposes various restrictions on the owner's power to protect the hirer. One could argue the Act was passed to remedy the literal reading of common law. Section 16 until Section 19 of the Act are vital. To uphold these laws, the Hire Purchase, Recovery of Ownership and Maintenance of Records Regulations 1976 must be enforced together. The owner's weaknesses can be briefly defined in two scenarios, before and after repossession.
I will start with the first case, which is Pang Brothers Motor Sendirian Berhad versus Lee Ai Seng. In this case, it is to be noted that the section which was used in this case had been wrongly quoted as Section 15, Subsection 1 of the Hire Purchase Act 1967. The appellant and the respondent enter into a hire purchase contract on a car. The respondent, as the hirer, failed to pay the installment due under the hire purchase agreement. Then, the appellant issued a notice under Section 16, Subsection 1 of the Hire Purchase Act. The respondent did not comply with the notice, as he said the vehicle was repossessed, and later he filed a writ against the appellant saying that the repossession was illegal. The previous session court held in favor of the respondent and ordered the car to be returned. Moreover, the court also awarded special and general damages. The appellant dissatisfies with the decision and appealed. The issue of this case is whether there was sufficient compliance with Section 16, Subsection 1 of the Hire Purchase Act.
Next, we move on to the sections related and the analysis of the case Pang Brothers Motor Sendirian Berhad against Lee Ai Seng. This case is a clear-cut case, although it was brought to the Court of Appeal. Only one section that was used in this case, which was Section 16.1 of the Hire Purchase Act 1967. However, this section had been wrongly quoted in the reported case as Section 15.1 of the Hire Purchase Act 1967. The section states that, subject to this section, an owner shall not exercise any power of taking possession of goods comprised in a hire purchase agreement arising out of any breach of the agreement relating to the payment of installments unless there have been two successive defaults of payments or a default in respect of the last payment and he had served on the hirer a notice in writing in the form set out in the fourth schedule and the period fixed by the notice had expired. This period fixed by the notice shall not be less than 21 days after the service of the notice. Therefore, the Court of Appeal had applied this section according to the facts of the case, as the appellant had failed to comply with the requirements stated in Section 16. This is because the section had specified that the period to be served in order to possess goods in hire purchase agreement shall not be less than 21 days after the notice was served, before any seizure of goods can be made. In this case, the date specified in the notice was 20th of March, and it was 2 days short to the minimum requirement stated in the Act. The date supposedly to allow the seizure of goods under the notice was 22nd of March. Thus, the Court of Appeal had dismissed the appeal according to the Section 16 of the Hire Purchase Act 1967 as the notice served itself by the appellate was valid in law. Next, we move on to the case of Hong Leong Finance Berhad against Mike's Double Construction, Malaysia Sdn Berhad, and others.
The first defendant entered into such hire purchase contract with the plaintiffs, and the second to fourth defendant acted as joint and multiple surety on this agreement. In 1988, after the first defendant act was defaulted by inability to make payment due, the plaintiffs sent a letter of demand. The plaintiffs then began civil proceeding in the High Court to sue the first defendants for debts owed on these agreements. On 6 September 2000, after the first defendant rendered certain fees, this lawsuit was ended with freedom to file again. Consequently, there's another failure after the partial payment of prior failure, and the plaintiff started this case for the remaining amounts due as of 1 October 2003. The plaintiff now says the amount owed for the 7 out of 11 hire purchase agreements, the 4 are completely resolved. The issues are whether the first defendants as the hire as well as the second and fourth defendants' sureties were released from the obligation by the virtue of the dismissal of the earlier actions against them. The second one, whether the effect of notice of discontinuance filed by the plaintiff has entitled the defendants to reimburse. The third one, whether the claim made by plaintiff is effective. And the last one, whether the plaintiff is entitled to claim balance of hire purchase installment from the defendants.
In this case, we attempt to ascertain whether the plaintiff is eligible to the remaining hire purchase installment payments. It is important to remember that if a hirer falls behind on installment payments under a hire purchase agreement, the finance company or owner can impose the contract against the hirer any right to claim the goods from the hirer and any contract of guarantee pertaining to the said contract. After repudiating the hire purchase deal, the plaintiff is only eligible to recover areas of installments and compensation. It will not be permitted to recover any remaining outstanding installments at the period of the dismissal. The plaintiff is only entitled to seek areas of installment due at the time of termination, not all of the installments due under the agreement, only if the plaintiff terminates the agreement with the first defendant. However, if the hirer is accused of violating the contract's condition, the hirer must understand exactly what went wrong and what he or she must do to make things right. In our situation, the plaintiff cannot sue over the unpaid potential installments on a hire purchase because it chose to break the deal first. It will not sue over installment area plus penalties. The agreement's clause granting the complainant the ability to sue future unreasonable installments violates the contract law principles. The innocent party will be allowed to exert the remaining amount of the installment by the time of the rescission of the deal, and any unpaid installments will then be exerted as penalties. In this case, the plaintiff decided to suspend the contract, and hence, he has the right to pursue only specific performance of the contract, not all outstanding installments, as according to the case of Haji Taib and Ismail. To render a contract invalid or impossible to be enforced, it is not mandatory that the law forbid or deem it unlawful under strict penalties. We have to comprehend that Clause 8 of the hire purchase agreement states that the owner, which is the plaintiff, has the right to terminate the agreement if the monthly payments for the hiring of the machines are not made on time, giving the owner the right to ownership of the machines rented and the payment of outstanding installments before and after the termination minus the aggregate of the sums already paid under the agreement. The letter detailed the amounts owing prior to the termination of each hire purchase agreement, taking into account also the deduction made under Clause 9 and for each agreement. The defendant's contention that the plaintiff's argument is faulty as its sum claim in the claim as of 24th February 2004 was not corroborated by the plaintiff's witness, and that receipts D25 to D31 were not attributed to the first defendant's account is inaccurate and misinterpreted. On the contrary, the plaintiff letter to the defendants dated 21st July 2000 indicated unequivocally that the termination was with liberty, a phrase that widely used to assert that a party's right to refile a lawsuit. The fact that the third defendant did not attempt to have been signed by the third defendant's attorney is irrelevant. The third defendant is jointly though severally liable, and the plaintiff is not pursuing the third defendant who has since died.
Allowing the plaintiff claim, the plaintiff can revoke the hire purchase contract pursuant to Clause 8 if the first defendant hire fails on his monthly installment. The fact established that all 7 hire purchase contracts had been cancelled in accordance with the plaintiff's mail written 28 August 1988. and thus the first defendant was obligated to compensate the plaintiff the amount requested under 7 hire purchase contract in accordance with the letter of demands.
In conclusion, both cases that we have reviewed, there is a wide application of the Hire Purchase Act 1967. It is regarding the payments that were overdue for months not being paid as stated in the agreement. In the first case, it was regarding the plaintiff who claims for the balance of payment that was due and is not being paid by the plaintiff. The first case ends with a freedom to file the lawsuit again to settle the case. As for the second case, it was regarding an overdue of payment of 4 installments and the plaintiff wanted to be in repossession of the vehicle. The appeal was then dismissed as there were doubt on whether or not the notice of repossession by the plaintiff had been served. For the recommendations, based on the first case, we recommend that detailed explanation in each section of the Hire Purchase Act 1967 and Contracts Act 1950, as well as other legislation that may be used in a case, to be read thoroughly when applying it. Second, we can see how the plaintiff made an appeal to court every time the defendant was late in paying his installments, not according to the agreement they had. However, after the defendant had paid, the plaintiff then withdrew his claim. This situation kept on happening every time the defendant was late for his payment. From here, we can see that the plaintiff will file a claim to the court in order to make the defendant pay. This means that we need to ensure in the Hire Purchase Act as well as the Contract Act, parties to the contract need to ensure that the contract they are entering into has all the requirements that have been stated in the legislation. It is important to regulate the use of HPA and Contract Act in order to protect the agreement and the rights of the party to the contract. When drafting the agreement, the parties to the contract must clearly lay down the proper sanction for the parties who do not comply with the agreement in order to protect both parties' rights instead of going to the court every time a party is late for payments. As for the second case, we recommend that 21-day notice should be taken into account by the plaintiff in order for the plaintiff to be able to claim for repossession as he had given the notice earlier according to the HPA. Even if the notice given was only for 20 days, the defendant still is late to pay for the installment. Thus, we also recommend that appropriate sanctions be taken against the defendant as it is infringing the rights of the plaintiff and cause the plaintiff loss if the defendant is late to pay for the installments. Thank you.